My Lord, can I just pick up on one point? My Lord Justice Nugee made a few points on the assignment agreement. The point about did it really matter to Devon Park? And I just wanted to refer you to one or two extra provisions, or just make one or two extra points on that. First of all, it's not just the warranties that, of course, we rely on. It's the recital which I showed you with the confirmation that SHI was 100% the owner, and also the indemnity provisions from SHI. And it is important, of course, to note that SHI was a party to a deed. This wasn't even just a contract, it was a deed. And Devon Park had shown itself to be very concerned about the legalities, and one would expect them to be, but they had actually shown themselves to be very concerned about it, not just apropos the parties to it, but because of tax and money laundering issues. And that's why they, I think we can safely say, they would not have been happy with it being not knowing the full picture for that reason. And we see evidence of their concerns about tax and money laundering issues in the context, admittedly, of the onward sale to Universal. In the bundle, I'm not going to ask you to turn them up, but it's Supplemental Bundle 3, tab 32, page 893 and 945. And respectively, there's the money laundering and the tax concerns. It is right to say that that goes beyond just who the party was. The other point is that the document provides, or the documentation we saw, provides...
Do we infer from that, or did the judge infer from that, I should say, that somebody must have told them who Universal was?
No, my point, my lord, is that they would have wanted to know that VBI was the actual holder,
yes,
rather than SHI, if that were true. And those concerns were expressed. I'm taking the concerns that were expressed about Universal because they were saying, effectively, don't mess us around. We want to know who the purchaser is, and we need to know that because we would be concerned about money laundering and tax issues. That was in the context of the onward sale. My point is that Lord Justice Nugee was essentially saying, well, why would they have cared? Does it really matter?
I appreciate that. I think I was perhaps on the other aspect of your submission, which is, as you were showing us before lunch, you say that Universal is essentially Mr Vik.
Yes.
Well, if they were concerned to know who Universal was, do we infer that they were given an answer to that question, and therefore that their communications to Mr Vik about capital calls and distributions and so forth were on an informed basis?
Yes, we do, because they obviously thought that Mr Vik was Universal.
Yeah.
I mean, the interesting thing is that the judge was going down a slightly different route, wasn't she? She thought that Universal was Mr Vik's father.
I think the judge...
She said highly likely, although she wasn't able to be sure. That was at para 340 of the judgment.
That's right, in the context of Mr Vik saying he had no interest himself.
And it was denied for Mr Vik that Universal was owned by his father as well.
Yes. So the judge did go down that route, and we don't know, but certainly certainly Devon Park thought Mr Vik was the person to be receiving the capital
information.
Well, Devon Park's pleaded case in Delaware, I think, was that they'd been told by Sebastian that it was Mr Vik's father.
Right. You're absolutely right, they were. But that's evident in the documents.
But we've not had any of that material.
I put it to Mr Vik, and he said they were wrong. They were lying, and it was all a conspiracy against him, I think, was the point that he made. We'll find you the reference.
Yeah, well, I mean, it doesn't matter.
But that was put to him, and he denied it, but didn't say why they would think that, and also couldn't explain all these documents where Devon Park really obviously thought he was Universal, because all the documents were addressed to Universal, and Universal was, as I've shown you with the tax points, was registered with the address of SHI. And the point I mentioned yesterday, and again we'll find the reference to it, is that when it came to it, I think Mr Vik and Mr Matthews in closing suggested that the tax authorities may have been misled.
But that's fine. Misleading tax authorities is not a problem. Is that?
Of course.
But that was apparently better than it being the court being lied to, for now anyway. So that was yes is your answer. My answer to Mr Mayor's question. The other point I was just going to make on why it mattered to Devon Park, just so I can finish that point, is obviously that Devon Park had to give its legal consent to the transfer,
Yes.
and as a condition of the transfer happening at all, it needed to be satisfied with those warranties and indemnities. And the indemnities were one of only a number of rights obtained as against the assignor and the assignee. And what we can see is, on Mr Vik's case at best, they were deceitfully induced into the agreement, even though they might have needed to look to the seller. And it would have mattered to Devon Park, A, because they wouldn't have agreed to it, but B, because in this scenario, they would have gone after SHI potentially for those indemnities, and SHI could have said, well, I've got no assets because we've sold them all to VBI. And then that would have left Devon Park with a problem. It didn't have an indemnity from VBI. So it did matter. Obviously, it also demonstrates the lie, but it does actually matter. And it matters because this court should have in mind that Mr Vik's best alternative case to the lies he's being asked about in the contempt is, I just lied to other people. Turning then to the IFA shares, this was addressed very briefly, and I will address it very briefly also. It's grounds 7 and 8, which we address in our skeleton argument at 188 to 191. Grounds 9, 10 and 11, which we address in 192 to 204 of the documents, and then sentencing I'll come on to briefly as well. The IFA shares provided yet further material undermining the bona fides of the sale agreement, and the judge dealt with that in detail at 354 to 379 of her judgment. Mr Vik's evidence at the Part 71 hearing was that SHI sold the IFA shares to VBI in 2012 under the sale agreement. SHI, it said, then held the shares on trust for VBI before transferring them to Universal again. So his case is VBI was the owner. So it was SHI, then VBI, then Universal. And the judge rejected that. And the judge's finding in the context of Devon Park about the sale agreement would have been enough. But in fact, she made further findings because the schedule I showed you, created by Mr Johansson, the one that your lordship, I gave you the little copies of, showed that the schedule suggested that SHI held the shares in IFA as at the date of the creation of the schedule. That's what he said, or it was supposed to be backdated to 2012. Just to remind you, it's at tab 33 of the core supplemental bundle. Now, this was inconsistent with Mr Vik's case in the context of the application 2014, the 2014 conditions application, because one of the documents he served in evidence was a contract entitled Securities Lending Contract, which is in the core supplemental bundle at tab 21. Now, this document purported to show that SHI had transferred the legal interest in the IFA shares as long ago as October 2008 to another Vik entity, VBV. So there's a direct inconsistency between the material that Mr Vik had disclosed and the sale agreement and the schedule created by Mr Johansson together with the sale agreement. And you can see with this agreement, it is dated the 20th of October 2008 on page 165, with Mr Vik signing on behalf of both parties. the lender and the borrower, and the lender is Sebastian, the borrower is VBV. Page 163 provides for a loan, and section 2.1 provides for a transfer of the title of the shares, subject to an obligation to return securities of the same type and quantity, section 2.2.
So it's not necessarily inconsistent, but there would be documents missing between 2008 and 2013-14 if it wasn't inconsistent, because they could have been part of a securitisation for a commercial loan, and then retransferred when the loan was repaid. But you need other documentation to prove that.
Well, and also, my lady, Mr Vik, in his evidence before Mrs Justice Moulder, conceded that he personally was the owner of the shares in 2013. So then his case changed again, and that was incompatible with his case that SHI was the legal owner. And the judge noted that inconsistency in the judgment at paragraph 358 and 366.
How did he come to be personally the owner of the shares in 2013?
Well, I think his evidence was that actually that's how he explained or tried to explain all the different inconsistencies and why he was able to transfer them to Universal. Right. I think along the lines your lady has suggested, that he suddenly tried to suggest, oh, well, actually, I was able to transfer them back and forth.
Right.
And they did go to Universal. And I think he said that VBV was liquidated to reach that, and there's a settlement, and that's how he became the owner.
Right.
So, having been caught out with the inconsistencies, he then created new evidence to try and suggest that, in fact, it was all true. It's just he'd forgotten to mention that the shares came back to him because VBV was liquidated. So, along the lines your lady had in mind, but there's no documents to prove it.
Right.
And when the inconsistencies between the Part 71 testimony and the underlying documents were put to him in the committal hearing, his evidence was riddled with inconsistencies, which the judge records in paragraph 363 of her judgment. And first of all, he blamed Mr Johansson for making an error. Then he changed his position and said the schedule was right. And the transcript of that is in the core supplemental bundle, tab 4, page 33 of the bundle, page 102 of the transcript. And the judge found at 360 of her judgment that it was more material undermining the credibility of the sale agreement. And his evidence was also undermined by the regulatory voting right notifications which the bank obtained after the Part 71 hearing, which showed that Mr Vik had acquired direct voting rights in the shares in 2013. And those documents were summarised in 345 to 349 of the judgment. And so those are just a flavour, my lady and my lords, of the material that the judge saw. We address it at length in our skeleton, but that's yet another reason why the judge queried, and rightly queried, the bona fides of the sale agreement. There is a lot of material. The document contempt allegation is fairly self-evident. Mr Vik failed to disclose any electronic documents at all. And he ran his entire business by email, but didn't produce one. He also didn't produce the documents that Mr Johansson ultimately provided through a subpoena in other proceedings, and he also didn't produce the Carlisle and Brighton partnership documents which we obtained through Norwich Farmer Course.
Do you say he was obliged to disclose documents held by Mr Johansson?
Yes, because his case was that Mr Johansson gathered together the relevant documents for SHI, and that the documents Mr Johansson had were SHI's documents. and
Mr.
that
Johansson was employed, but not by SHI, by some other entity.
he was a litigation consultant to SHI. We'll find you the passages, but Mr. Vik's position was that Mr. Johansson had gathered together the documents for SHI, and then when it was put to him that how had he missed all of these documents, we got all sorts of inconsistent answers, including that his lawyers were to blame for filtering. So there was no, I think at one point in the evidence, Mr. Vik did try and suggest that there might be a distinction between Mr. Johansson and SHI, but it was backed down from. So, and Mr. McDonald's helpfully passed me, the judge recorded all of this in 427 of the judgment.
Thank you.
Onwards. So, yes, it's not that he was obliged per se to go after Mr. Johansson. It was that Mr. Johansson was the person who was gathering the documents for SHI, and it was very convenient that those unhelpful documents for Mr. Vik's case were omitted. But what they also show is that there were substantial numbers of electronic documents responsive, and so even if the judge had any queries about Mr. Johansson's role or the other partnership's documents, what it shows is there were clearly electronic documents, and Mr. Vik didn't disclose a single one. Very hard to justify that. And he tried to justify it by saying he had a deletion policy, and the judge went through very carefully the inconsistencies in his affidavit evidence and his oral evidence as to that deletion policy, and in particular he then tried to blame his lawyers in that context as well, and that was addressed in the judge's judgment in paragraphs 403 to 411 and also 404 and 412. Can I then address the points about the Carlisle deeds? And I'm going to come on to the new points. So the first point is that Mr. Matthews suggested the judge placed heavy reliance on Mr. Vik's non-disclosure of the Carlisle deeds in her findings on defective disclosure. That was day 2 of the transcript, page 59. And that's not right. I'm just going to ask your Lordship and Ladyship, not now, but to carefully review the paragraphs that my learned friend referred you to of the judgment. It's 415 to 417. And in fact, the judge referred there to Mr. Vik's deliberate attempt to mislead by disclosure only in support of a narrow point, which was to reject a submission by Mr. Vik that he had produced hard copy documents effectively. So the relevance of that was overstated. Can I start then looking at the new case that's been advanced? And you have my submissions that it's actually not permissible for this case to be advanced at this stage and in this way, in any event, and we are taking that point rightly. We say it's abusive. But putting that point to one side, it's also a bad case. So can I just start with the substantive finding the judge actually made on the Carlisle deeds? Because it's important to focus on what her substantive finding actually was. And that's at paragraph 95 of her judgment. So the judge found that Mr. Vik had sought to mislead in his disclosures of versions of the Carlisle deeds and lied when he said in evidence to the court that he had only disclosed what he was given by Mr. Johansson. So that's the finding the judge said was relevant to her assessment of credibility. The signed twice point referred to at the judgment in paragraph 92 was just one element of the reasoning she relied on in reaching that conclusion. Now, the finding the judge made was one she was entitled to make, undoubtedly. The key points are as follows. As your Lordships are aware now, In October 2008, Mr Vik became aware of SHI's enormous liabilities to the bank, and that was in Mr Justice Cook's trial judgment at paragraph 1463. It later emerged that at this time Mr Vik transferred nearly $1 billion of assets out of SHI, including the money sent to Beatrice. In April 2013, the bank carried out public searches of the London Gazette, which stated that the Carlisle interests had been transferred out of SHI to Delagoa Bay on the 2nd of December 2009. And it may be worth having Mr Hart's affidavit to hand, because all of this was set out there. And this is in the supplemental volume 2 at tab 12, page 412. And it's paragraph 146. The timing of the transfers, long after Mr Vik became aware of SHI's liabilities to the bank, suggested there were further examples of asset stripping. So the bank wrote to Travers Smith, SHI's solicitors at that time, to seek an explanation and the relevant documents. And can I hand up the letter that I've mentioned now a few times? Mr Matthews has a copy of it already. This is the letter that Travers Smith wrote. And it's paragraph 9 of the letter on page 2.
Thank you very much.
Thank you.
Thank you.
I invite you just to read that paragraph.
Did you say paragraph 9?
9.
Yeah.
On page 46. Now in sorry, I'll have to read that. In October 2015, 2 years later, Mr Vik suddenly produced versions of the Carlisle transfer deeds just before the Part 71 hearing. And as you know, they contain dates in handwriting and were marked version 5. And if you could look in the core supplemental bundle at tab 3, please. Tab 20, please. And if you go to page 142, you can see that this is the version. I'm going to come back to it. But these deeds stated consistently with Mr Vik's position and SHI's position and correspondence that the transfers were effective and entered into in September 2008. And these were the only transfer deeds disclosed by Mr Vik.
And it's not only 2008, but it's September, so it's before he would have been aware of the October debacle.
Yeah, exactly, that was the point of the date.
Yes.
Exactly. And during the Part 71 hearing, he gave evidence asserting consistently with these deeds that the transfers took place at that time. And that was in the Part 71 transcript, supplemental bundle 1, tab 1, pages 24, 25 and 29 of the bundle. Now, after the Part 71 hearing, the bank obtained the Norwich Pharmacal orders against the Carlisle General Partners, and they then disclosed execution versions of the Carlisle deeds, and they were different. And again, I'm going to come back to them. And you've seen the example, which I'll come back to, which is at Supplemental Bundle 2, tab 25. And they made it clear, contrary to the case set out, that the transfers were effective from the general partner's perspective only in September 2009, and that the transfer agreements were not made until the 2nd of December 2009. So in light of the inconsistencies between the two sets, the bank then asked for and obtained drafts from the general partners, matching the version 5 number on the Vik Carlisle deeds. And this is set out in Mr Hart's statement in Supplemental Volume 2, paragraphs 161 to 162. And that's pages 422 to 423. And those are not in the bundle because this point hadn't been raised, but they were referred to and exhibited in Hart 1, included in the committal hearing bundle, and they were put to Mr Vik in cross-examination on day 7, which is Supplemental Bundle 1, tab 5, page 205. And the draft Carlisle deeds showed that the Vik Carlisle deeds, if we're calling them, so if I call the 3 sets, the Vik Carlisle deeds, that's version 5, the executed Carlisle deeds, that's version 6, and then the draft Carlisle deeds, this is the 3rd version. They show that the Vik Carlisle deeds, the ones Mr Vik actually disclosed, were created by blanking out the dates in the draft deeds and writing over them with handwritten dates backdated to September 2008.
Ah, so what they showed is that the draft version, which I had called, I think, version 5.5, is actually the first in time, and that is the template for version 5. Is that what you're saying?
Exactly.
Do we have that version, the one disclosed?
We've got, we thought it was easier given the amount of material to take it from Mr Hart's statement. We can get you copies if you would wish, but we thought that the text is set out in Mr Hart's statement. If you look at it in paragraph 161.
For some reason I don't quite understand it. It's always more telling to look at the original documents than simply what someone says about them.
That's fine. We can get the copies to you, but if, for the moment, my lord, if you could look at 162, this shows
Supplementary
the text.
2, is it?
It's 162. Sorry, supplemental volume 2.
Sorry.
Tab 12, 162. That shows.
Thank you, sorry.
We'll send. We didn't want to now introduce a whole set of deeds, which I don't think I will have time to go through in the time I've got. So that's why I'm taking it from here.
Well, he sets out very clearly what it says, but as I say, it is actually quite helpful seeing the original
I
document.
understand that, and we'll get you copies of them. Now, the conclusion is also supported by the contemporaneous email communications between Mr Johansson and the general partners, which are referred to in paragraph 158 of Mr Hart's statement, and the judge was shown some of those communications, and that was on day 1. Sorry, you were shown some on day 1 of the appeal, and the judge was shown some as well in the opening. The communications confirmed that the transfer deeds were not executed in 2008. These are the Debevoise emails. And material changes to the terms of those deeds were being made as late as October 2009. So when all of the documents are put together, the key point is that the judge's finding in paragraph 95 that when pursuant to the CPR 71 order, Mr Vik disclosed only the Vik Carlisle deeds, not either the executed or the draft deeds, he was misleading the court. And he disclosed amended documents supporting his case, but failed to disclose the genuine documents. So can we go back to core supplemental bundle tab 20? These are the versions he disclosed. So you see here, they contain text handwritten in of the dated September 28, 2008. And you see there's handwritten amendments to the Cayman Company. And then if you go down right almost to the bottom, paragraph 1, the transfer of interest, you see the handwritten dating again.
Yes.
And that's headed transfer of interest. And you see version 5 is in the footer at the left bottom of the page. And they are purportedly executed by Mr Vik and witnessed by his wife on page 160 to 162. And what you can see is that the general partner doesn't appear to have signed this version. Now, the bank doesn't know if the Vik Carlisle deeds are in fact a single document as they appear to be, because no electronic version or metadata was disclosed by Mr Vik. And it's not clear if the handwritten signature pages were attached to them or not. We just have no way of knowing. By contrast, the executed Vik deeds, which are in volume 3 at tab 25,
Aren't they in the same core supplemental at tab 25?
not in full,
Oh,
which is why
we need pages which are not in.
I think maybe.
All right.
I'm sorry about this.
Sorry, Mr.
It's
Delaney,
been
can you possibly give me the reference again,
Supplemental volume 3, page 20, tab 25.
Thank you very much.
It's rather infuriating. That it's sort of hodgepodge.
Yeah, that's it.
What you see here
Yeah.
at page 724 is a typewritten date, not handwritten. And rather than the text I showed you in transfer of interest in paragraph 1, you see that it's entirely typewritten and that there is additional text in there, typewritten, acknowledging that the assignor and assignee have agreed the transfer shall be effective as of September 28, 2008, provided that it's recorded as having taken place and it actually did later.
Yes.
And the version is said to be version 6 at the footer, except for the signature pages,
Which is version 5.
which is version 5. But unlike the version 5 signature pages in the Vik Carlisle deeds, these ones at pages 742 to 743 have a fax header. And they were faxed from Mr Vik's office to the general partners. They're also executed by the general partners, and you see that on page 744. And they have appended to them extensive exhibits not appended to the Vik Carlisle deeds. And you can see that pages 745 to 763. And I think, my Lord Justice Bales, these are the extra that are not in the court.
Well, there are only two that have got the fax header, which are 742 and 743. The general partner one is not, and it says version 6 on it. And then the one after it says version 5, so it's quite interesting. The signature page for the general partner has version 6 on it.
Yeah.
And the others have got version 5, and some of them have got version 5 without a fax, and others have got version 5 with a fax. But the two pages that have got the fax on are the signature pages, which appear to the uneducated eye to be identical to the ones in the Vik deed.
Appears. I agree. And what you can see when you go back to Mr Hart's statement is that if you look back at paragraph 162, that was what the draft deeds look like, so you can see that they had some gaps in there. Which we think were the ones that were blanked out and then handwritten over. So, yes, paragraph C, the draft are dated May 15, 2009, which is consistent with the correspondence that we've seen in the bundle. So what we can take from that is that the Vik Carlisle deeds were not created by Mr Vik simply executing drafts that Carlisle had sent to SHI in or before September 2008, as would appear from their face. And they were created at some point later, again we do not know when. And that's the point made in paragraph 163 of Mr Hart's statement, and why the judge correctly referred to the handwritten versions as being deliberately amended or deliberately altered, as my Lord Justice Mayles observed yesterday afternoon at page 128 of the transcript. And further indications that the Vik Carlisle deeds were not genuine but amended and backdated comes from the emails. So, as Mr Hart notes at paragraph 158b of his statement, it was only in April 2009 that Mr Johansson first informed the general partners that Delagoa was the purported transferee. So that undermines Mr Vik's case that Delagoa had agreed back in September 2008. No evidence of that. And the relevant email isn't in the appeal bundle, but referred to and exhibited to Mr Hart's statement. And again, we can provide a copy if you'd like to see it. But you can see the mischief of a new case being advanced as it is, because a lot of this material hasn't been put in because it wasn't an issue. Mr Hart then notes in paragraph 158C to G the contemporaneous communications between Mr Johansson and the general partners lawyers, Debevoise. And as he says, what they show is that Debevoise writes in August 2009, raising a number of outstanding issues to be cleared up. And this is in supplemental volume 3, if you want to see the emails again, at tab 24, page 718. Mr Johansson seeks clarity as to what they are, and by an email of the 26th of August 2009, Debevoise explains that, amongst other things, certain signature pages supplied by Mr Johansson had not been witnessed, and that a more recent effective date should be used for the transfers. And Debevoise offered to send back the original signature pages to facilitate the witnessing process. Now, it's clear from this email, as my Lady Justice Andrews pointed out on the first day, that at this stage Mr Vik had signed versions of the deeds, but they'd not been witnessed. So it follows that there were at least 2 versions of the deeds signed by Mr Vik, since the later versions were witnessed. Certainly that's how it appears from this communication.
Well, it doesn't mean he signed it twice. It's possible that the first time he signed it and the second time his wife simply signed that she'd witnessed it.
But that's a criminal offence.
Well, yes.
So, and that case, my lord, was not
Your
advanced.
submission is that's inconceivable that either of the Vics would commit a criminal offence.
Well, my lord, of course.
The truth is you don't know.
But
One
my
simply
point,
doesn't know.
But my point here is, we're going to come on to it, saying that the judge got it wrong that he signed twice. Come on to that. There is a reasonable basis for the judge thinking he had signed at least 2 versions.
Not strictly speaking, signing version 5 and version 6, which is what she said.
Well, It may be that the way it was expressed was in blisters, but she may well have had in mind that there were at least two versions that he signed, and that there is material to support.
Well, there is, because you've got, as you rightly say, you don't know whether the version that we can infer existed as a result of this email was a different version with his signature on it but without his wife's, and that what we've got in the bundles is the one that was eventually witnessed properly by her.
Yes. And I know that Mr. Matthews tries to hang his hat on, oh, this all arose from when because the judge found this point. But obviously, this was all about why the Carlisle deeds were genuine or fake. That's what this point was about. And our case since, well, really 2015, at the Part 71 hearing, was they were fakes. So the idea that if there was this reasonable explanation over all of it and how they came to be executed, and that they were somehow witnessed later, but it was all done legitimately, some of which is tried to be alluded to, but I'm going to come on to the note, in the new note produced on day 2 of this appeal. All of that was something that we should have been able to cross-examine Mr. Vik on, either at the Part 71 hearing, he should have told us, or at the Committal hearing. So the judge can't be criticised for having found or thought that there may be multiple versions of this that he had signed. And insofar as Mr. Matthews wants to advance a new factual case as to what actually happened, that is impermissible at this stage because it doesn't actually stem from the minutiae of an error, if it is an error made, because the ultimate finding is that he misled the court, and that stands.
Does it come to this, if we do go into this, and I know you say that we shouldn't, that it looks as if the judge was wrong to say that he signed both version 5 and version 6. She may be right to say that, or she might have been right if she had said that he signed version 5 twice, but we don't know the answer to that. But that, in any event, this is a very murky story which Mr. Vik has not explained, and in any event further to that it is only one aspect of the judge's reasoning in relation to the non-disclosure of documents relating to this. Is that a summary of where your submissions take us to on your case?
It is, and there's one further submission, which is that insofar as Mr. Matthews tried to pin all his hopes on this one point as undermining everything about Mr. Vik's general credibility, we say that submission's hopeless. A, because even on this finding alone, the signed twice point isn't at the heart of it. No. It's the misleading the court. And B, you have all my submissions on how everything else built into this means that this was a point in the general credibility section. But in any event, now I've taken you through what I've been able to of the Beatrice, IFA and the documents contempts. Even if you put all of Mr. Vik's general credibility to one side, the contempts would still stand. And it's important just to mention a point to you, my lord, in this context that I'm sure your lordship has, but obviously the bank only ever needed to prove one contempt. In fact, we proved, I think, almost every single allegation of lying that we, in particular...
All but one, I think.
All but one. The Zimmerman Ghosh was the only one that we didn't prove to the criminal standard. But we only had to prove one contempt because this is all about a man, and it's important again to say this. I appreciate this appeal is about whether the judge committing Mr. Vik to prison on a suspended sentence was right. But the context of this is a man who, since 2013, has been found, having been found to be the real party shortly after that, to have asset stripped his creature company, caused it to bring litigation with a false and fraudulent counterclaim of 8 billion with fabricated documents in the actual defence to his claim, and has since then evaded a judgment debt to the bank for 10 years, whilst he's used the courts of this jurisdiction as something of a playground, treating it like a sport. And in the end, what we've seen is that even on basic disclosure, he has not obeyed the orders of the court and has been caught out by other activities the bank has gone down to try and get documents. And even when presented with all of that, still doesn't give an honest picture or answer. And even on appeal, on day 2, is running an entirely new case at the heart of his appeal. And one is minded to remember the words of Mrs. Justice Whipple in the Nazaroff case, that this court can't be brought into disrepute by people who deliberately disobey court orders and face no sanction. And this is the context of it all. That doesn't mean the bank didn't have to prove to a criminal standard everything it alleged, but it did, and it only had to prove one. So the idea that the one small error that it's taken months and months to identify and has only been articulated on the first day of the appeal somehow unravels this entire judgment is almost monstrous. But it actually is not the right analysis at all. And what I was going to say is the error the way the judge could have expressed it was that Mr Vik must have known that there were 2 versions of the documents, each with his signature page attached. And she had a basis for that. So, my lord, what we can also see, just while I'm on this point, is that Mr Johansson replies to Debevoy's email saying it was unnecessary to witness the signature pages as it just takes time. And again, that's consistent with multiple versions floating around. So what we say is, and he also says, sorry, as well, in one of his emails, he had asked Debevoise to use the signature pages he had twice earlier provided, but they insisted on fresh signature pages. And that's page 719 of the clip that you're looking at supplementary.
In the end, Debevoise must have agreed to use the signature pages he earlier provided, because that's what ended up in the execution version.
But they presumably may have thought that he was using this, because they offered to send original versions, presumably from the draft, and I assume they will have thought he executed it with his wife witnessing it rather than just adding the signature.
My point was, Debevoise was saying, we've been told by the Law Society you shouldn't recycle signatures, you should sign the final version.
Yes.
Which is plainly right. And Mr. Johansson says, we can't be bothered, in effect. And in the end, Debevoise must have accepted that, because they did use the recycled version 5 signatures.
Well, they may not have known, because they sent revised drafts on the 20th of October 2009, according to the email at page 720.
Fax predates it.
That predates it. But they may not have known.
But the fact, no, I think they must have known, because the fax which has got the final version that finds its way into the executed version was sent in September.
Right.
I mean, if they had a signed version of version 6, that would have been responsive to your Norwich Pharmacal order, and that is what you would have got. So we can safely conclude that they didn't, can't we?
I think we, not necessarily in the sense that, I think we just don't know what they thought had happened. I accept the timing point, but it may be that whoever got it didn't consider it very hard. They just knew they got one with a witness signature on.
It doesn't really matter.
It doesn't. But
it does illustrate something which has long puzzled me, which is that in Scotland, when you sign a deed, you date your signature, which is different from the date that the deed is dated, which is when everybody has signed it. But in England, we've never done that. I don't understand why.
maybe after this case we will.
Well, I very much doubt it.
New law in unexpected ways. But what you can see from this entire debate, though, is that there's something extremely fishy, irrespective of the signature page point. The point is that how did these handwritten dates come in and
The
why.
The Vik version stinks to high heaven. It's basically the point that you're making, isn't
Yes.
it? The version that was produced as indicating that there was already in place a bona fide transfer agreement as at September 2008, which was the key date. There's plenty of evidence to suggest that that document was created in 2009, irrespective of when it was signed, and that Mr Vik would have known jolly well that it wasn't a 2008 document, but he was presenting it as such. That's the real point.
Exactly. And, my lady, I should address the fact that the factual note that's been served, of course, doesn't actually just focus on the signed twice point. So it's gone beyond the submissions made on day one. And it now is in substance an attempt to answer the core allegation that Mr Vik's disclosure was not misleading. And you see that in paragraph 16 of that note, where it said that contrary to the judge's findings, there was an obvious explanation for the handwritten amendment. Now, it's difficult to understand precisely what the explanation is, but the explanation seems to be that Mr Johansson might have done it and sent them to Carlisle at some point. So the new case is in fact trying to justify the whole manipulation. Now, what that shows is that that was the issue below, and there's no justification for a new case being run on that, and there's no hook in the judgment for that, because Mr Vik had every opportunity to explain the manuscript amendments and chose not to advance this case. And I can't resist the observations of Lord Justice Lewison that the trial is not a dress rehearsal, it's the first and last night of the show, which does seem to be apt in this case. In any
I think
case,
a judge in the commercial court said recently that if there were royalties going on judgments, then Lord Justice Lewison would be a very rich man, or something.
He has
to that effect.
a wonderful turn of phrase, island hopping and others. My lord, the second point, which is equally significant, is that the new case is pure speculation. There's no evidence before the court supporting it. There's no affidavit from Mr Vik or Mr Johansson. There's nothing in any of the materials that you've seen, and there's quite a lot of material that would support it. It's speculation, and it in part seems to also turn on the idea that Mr Johansson might have done it all and it's nothing to do with Mr Vik. And insofar as that is concerned, that's not plausible. And just one point of detail on that, Mr Vik and Mr Johansson, at least we think in 2008-2009, had adjacent desks in Mr Vik's office. They worked pretty closely together, and instructions were given by Mr Vik to Mr Johansson when they sat there. They were clearly on email all the time, as we've seen. It's not plausible, and one without evidence couldn't reach that conclusion. And when you put together all of the material you have, including the Travis Smith denial, the production, the lack of explanation, the pulling out the documents from other sources, you can see that this is not a good explanation. And if it were a good explanation, we should have had some evidence a long time ago, certainly even now. And it's an explanation that's developed between day one and day two of the appeal itself. So, my lord, we say for all of those reasons, we suggest that the new case is hopeless. If there is an error in the judge's judgment, and it's not just a poorly expressed paragraph, which I think is one possibility here, the other is that there's an error, but it's not a fundamental error that would disrupt any conclusion on any point. My lord, can I then turn, unless you have any further questions, to the sentencing aspect? So, I've already made the point that the bank actually only had to succeed on one contempt to reach a point of sentencing. obviously, if the court were to find that not all the contempts have been made out, that might have an impact on the sentence. But even then, it's not necessarily just the sheer number of contempts, it's the seriousness of them. Here, we would say all of the contempts found by the learned judge stand up, and one can see that they are all very serious because they involve lying and evading, and one has to set that against the background, as I've said to you, of how this case has come about. Now, one of the reasons the bank is always in a difficult position is because Mr. Matthews is always very keen to say, oh, the bank's trying to poison the court's mind by the context and the history. And it's also fair to say that the sheer volume of judgments, including the trial judgment, is always mildly off-putting to the person who's latest in the line to hear a case involving Mr. Vik. But the reason I mention this now, because it is relevant to sentencing, is that multiple judges at first instance, Mr. Justice Cook, Mr. Justice Tier, Mrs. Justice Cockrell, and now Mrs. Justice Moulder, and 3 prior constitutions of the Court of Appeal have all made a number of comments about Mr. Vik's conduct, and in some cases his honesty, not all of it, but in some cases his honesty. And although my learned friend says that the Court of Appeal's judgments are parasitic, what I've shown you an example of the Court of Appeal independently expressing disapproval on the conditions application. And that wasn't just simply repetitious of prior findings below. And the reason is that Mr. Vik has, first of all, evaded paying a judgment debt when there is every reason to believe he has the money. First of all, he has the money because he stripped the company of the assets. And secondly, he hasn't really explained what happened to those assets. So the very assets he's stolen, he's not demonstrated no longer or available, let alone any other assets he may have, given that SHI was his creature company, albeit I accept these purposes a distinct corporate entity. So he has not taken any steps to repay the judgment debt. He has also shown no remorse whatsoever, and that's been very apparent from the submissions made by his legal team, no doubt on his instruction, who challenge even the findings of Mr. Justice Cook, which aren't challengeable, we say, on admissibility grounds, and challenge that any court really hasn't been entitled to find that he is dishonest. So we're not dealing with a contemnor who's coming to this court saying, I know what I've done is wrong, I apologise, I will try and fix it. We're dealing with a man who has, as I say, treated this as a sport, something that Mrs. Justice Moulder observed in his cross-examination and his approach to the questioning over the 4 days. And all of that is relevant when we come to sentencing. We've dealt with sentencing in detail at paragraphs 205 to 219 of our skeleton. Can I make one correction? In our skeleton argument at paragraph 210, we suggested in the context of the Kia Investments case that there had been no finding Mr. Watson had lied to the court under oath, and that's incorrect. We've checked that. I know my Lord Justice Nugee will tell you that. Mr. Watson was found to have lied in his affidavit in relation to a single breach for which he was convicted, and in a witness statement filed earlier in the Court of Appeal on a related matter. And that was at paragraphs, I think, 251, 253 and 282 of that judgment. But it's fair to say that the extent and seriousness of Mr. Watson's dishonesty was of a fundamentally different order, we say, to that found by Mrs. Justice Moulder in relation to Mr. Vik. And we say that as regards to sentence, there's no basis to interfere with the judge's sentence. She imposed a sentence of 20 months imprisonment for the failure to give information at the Part 71 hearing, and 10 months imprisonment for failing to produce documents, with the sentences to be served concurrently. And she suspended that sentence for 6 months from today, from the determination of today's appeal. My Lord, the judge actually considered, and you will have seen a debate, no doubt in the transcript, as to whether she should suspend.
I mean, she's suspended on conditions which, if I've correctly understood, don't have to be complied with until after determination of the appeal. Is that right?
That's right.
But in fact, nothing has been done
Nothing's been done.
with a view to, well, obviously no further attendance for examination, but no documents provided either. No.
And the judge did consider, the bank applied for suspended sentence. There's been a long tail to this, so the judge, by the time she came to hear the application, years later after it had been issued, considered whether to suspend on the grounds that she expressed some scepticism as to whether Mr Vik would ever comply, given the history. But Mr Matthews pressed for the fact that a suspended sentence was appropriate, and it's right to say the bank had applied for a suspended sentence, albeit accepted the judge's invitation to reconsider that in submissions. The judge had a very wide discretion to impose an appropriate sentence for what are very serious contempts, and in a commendably detailed extempore judgment in the core bundle at tab 10, she considered all of the relevant principles, including the so-called minimum sentence principle, and applied them impeccably. And none of the authorities relied upon by Mr Vik suggest otherwise. There's no basis to suggest that her decision fell outside the reasonable sentence, and it's well established by the McKendrick case, which is in the authorities bundle at tab 42, at paragraph 40, that the top of the range is not reserved only for the worst offending, albeit as the judge held Mr Vik's offending was serious and deliberate. The harm and culpability was towards the top end of the range, and there was no mitigation. And indeed, there still is no mitigation. And the main attack on sentence, in certainly Mr Vik's skeleton argument, although not pursued orally, seems to be that the judge should have drawn comparisons with other cases. And we deal with that at paragraph 208, 15 of my skeleton. But that's actually a volte-face from Mr Vik's position below, where he insisted that prior cases were in fact irrelevant. So, and the Thursfield case suggests that prior decisions are not relevant unless the facts are effectively the same case. And that's Authorities Bundle, tab 28, paragraph 33. So we submit there are no grounds for interference with the sentence that Mr Vik gave. And indeed, there are just simply no grounds to interfere with the judgment. And as I say, that's really on two bases, but I only need to succeed on the first, which is nothing you have been shown would even touch the sides of the hurdle that Mr Matthews has to overcome, because the judge had every basis. She had so much material to reach the findings that she did. So this court could actually deal with this case, despite the length of the hearing, very shortly. And similarly, the new evidence, very shortly. If one delves into the facts, there may be the odd point that one or more of you may have taken a different view upon, but it would not have changed the ultimate conclusion because of the wealth of evidence relied upon by the judge in respect of each and every finding she made. So, my lord, there's just simply no reason to allow this appeal.
Thank you very much.
Please, my lord. First of all, legal principles. I propose to highlight only one point, and that is dealing with the element of the test relating to whether the decision below was wrong rather than the procedural element, which you have in CPR 52.21(3)(b, focusing on the decision below being wrong. All we would say in relation to that is by reference to the decision in business mortgage finance, with which my Lord Justice Nugee will be very familiar, in the bundles at tab A, tab 54 of the authorities bundle, at paragraph 99. In effect, the threshold in practice is lower in criminal cases and, by analogy, committals, because the cogency of a conclusion, which has to have been reached beyond reasonable doubt, will the more readily be undermined by any errors. But beyond that, as I indicated in opening, the matter has been ventilated recently in 3 Court of Appeal cases, and I'm not sure that I can usefully add a lot to the discussion of those. Turning first of all then on the basis of the appeal to credibility, and first of all previous decisions, I have to start with some trepidation by taking the possibility that I might have to refer the court to another authority, and I'll explain why. The court was taken to a number of the earlier authorities in this case, and points picked out at some speed from a succession of judgments to which the court was taken. And with respect, there may have been some confusion as to what does and doesn't survive from some of the judgments. And the particular one was in the context of Deutsche Bank seeking to answer the point which my Lord Justice Nugee raised, that the trial judgment findings weren't binding on Mr Vik because he wasn't a party to the trial judgment. And it was suggested that somehow they came in through the non-party costs hearing in front of Mr Justice Cook. And in that context, you were taken to the judgment of Mr Justice Cook in tab 3 of your bundles, and it appears to have been somehow suggested or indicated that that was some sort of relevant decision which was binding on Mr Vik in relation to the principles that were, as it were, incorporated from the trial judgment. So there's some sort of process by which Mr Vik became subject to those findings, even though they had originally been against SHI. And the short point is that Mr Justice Cook's analysis was based upon questions of privity, issue estoppel, and so on. That approach was rejected on appeal to the Court of Appeal. And your Lordships don't have in your voluminous bundles the Court of Appeal decision from Mr Justice Cook's decision, which rejected that analysis.
But upheld the non-party costs order.
Upheld the non-party costs order.
But on slightly different grounds.
Exactly, on the completely different point that the statutory jurisdiction under Section 51 to make a non-party costs order entitles a judge, when making that order, to take into account all matters that they have considered in relation to the procedure. And it's a very wide discretion.
And that can include the findings made against the principal defendant.
Exactly.
Yes.
Or indeed anybody.
Yes.
You don't have to have had any direct role in the case. You may have had an indirect role in the case and still under Section 51 be found liable to pay costs. And so the key point that I just do want to get across is that and we have hard copies of it, and I can refer to the particular paragraphs to sort of make it short and simple, if that assists. If I could pass those up briefly, and if I could just prevail upon your indulgence, I appreciate that it's adding to I did mention to my own friend earlier today that I was going to refer to this. Simply for this point, to make it clear to the court as to the circumstances in which, and the very limited circumstances and extent to which decisions that the learned judge may have made were relevant for the exercise of the Section 51 costs jurisdiction. They are not relevant for wider purposes. That's an important issue.
Thank you very much.
So I'm grateful. May I suggest it's tab 58 at the back of volume 6 of your authorities. And I'm sorry, in some ways I'm sorry it wasn't in there before, and in other ways it would only have made it worse if it had been, but I hadn't appreciated it was going to be suggested that the non-party costs order somehow, for wider purposes than costs, made Mr Vik bound or subject to the other findings that have been made. And you see from the case, the particular passages to which I would refer the court are briefly in the head note on the first page, halfway down the page, held dismissing the appeal, that the principle is there stated, and that runs halfway down that paragraph until the line on the left-hand side beginning were irrelevant to the claimant's application for costs against the second defendant. And then you get on to other aspects which we're not concerned with. But that first 10 lines of the head note encapsulates the principle that it's a special jurisdiction under Section 51, and it doesn't engage principles or rules of evidence relating to issue, estoppel, abuse of process, and so on. And it is a limited and very narrow basis upon which the findings of previous judgments, or indeed the case itself, may be relevant in relation to that. A very limited scope, and therefore it doesn't provide the basis for any departure from the normal principles as to and circumstances in which anybody is bound by or subject to or can be taken into account against him findings of fact in cases to which he's not a party. That is...
as I read this, having only had a very quick look at it, they don't actually say that Mr. Justice Cook was wrong in his conclusions in relation to Henderson and Henderson abuse or privity or the like. They say it wasn't necessary for him to go down that road at all in an application of this type.
Exactly. This Mr. Justice Cook's decision can't be binding on my client because by definition the attempt to appeal the point was not dealt with by the Court of Appeal because they held it didn't need to be dealt with.
Yes, I see.
So, but by no route is Mr. Vik bound by that aspect of Mr. Justice Cook's judgment in the non-party costs order. And I just didn't want there to be any confusion or misunderstanding about that, given that you had Mr. Justice Cook's complete judgment without appreciating that a significant part of it had been appealed and had been determined by the appeal court not to be matters that were appropriate to have gone into, and therefore not matters that the Court of Appeal determined whether he was right or wrong on, even though they'd been appealed. And you see this in a little more detail just back end of paragraph 5 of the judgment, the last few lines on page 3 of the report. The bank said that the judge's findings in the main action gave rise to issue estoppels against Mr. Vik, who was therefore bound by them, and that in any event it would be an abuse of process for him to seek to reopen them. And then paragraphs 6 to 8 explain why, although the judge dealt with those issues and made the decisions that he did, in paragraph 8, in our view, it's quite clear from these passages that although he dealt with many of the arguments raised by Mr. Vik, the basis of his order was the very close connection which he found to have existed between Mr. Vik and the proceedings in the main action, which was sufficient to justify holding him bound by the findings of fact in his judgment, i.e. for the purposes of Section 51. But if you then go on to paragraph 27, in addressing the argument in relation to the involvement and whether the symphony procedure should have been followed or not, the Court of Appeal said, halfway through 27, or a few lines down, we therefore agree with the judge. The court is not concerned in this case with the scope or application of the rules of evidence which would be applicable if this were an independent claim brought against an unrelated third party. The judge dealt with the arguments relating to issue estoppel, although in our view he need not have done so. With all due respect to the detailed submissions made by Mr. Cogley, we do not think that there is anything to be gained by considering the principles of law relating to privative interest, issue estoppel, abuse process, or the rule in Hollington, since none of them is relevant to the question we have to decide. And so that is ultimately, although the point was appealed, and whether it was correct to for the judge to have made his various decisions in relation to issue of stop and so on. The Court of Appeal determined that it wasn't necessary to decide that because it was a summary jurisdiction, Section 51, and therefore there is no binding authority that my client is indeed bound by the findings of fact in relation to that. So
The question remains open.
I'm so sorry, Biddy.
I think the effect of it is that the question remains open whether he is or isn't.
Yes, exactly. If and insofar as it may ever arise in any case, that'll have to be addressed. But of course, certainly doesn't, we say, arise in this case, because we say that there is no basis for saying those findings were binding on Mr. Vik, or that they were and should have been taken into account against him. The suggestion is made, well, it is right and proper and appropriate to deal with previous findings as some sort of sense check. We don't accept that is a correct analysis or basis upon which to proceed. But in any event, we respectfully submit that that's not what Mrs. Justice Moulder was actually doing. If you take her findings at judgment 327, 32 to 329, and 341, there is no suggestion that any of her findings were unnecessary or a mere reality check for her decision. On the contrary, she says that all the factors contributed to her conclusions, including, obviously, fabrication of documents, and the language of paragraph 327 to 329 of the judgment does not suggest they were being used as a mere sense check. She says at 327 that the findings support the view she's said to have reached independently, but by definition, if they support, then that must be part of that process. And 328 similarly. And it is distinguishable from the approach that Mrs. Justice Whipple took, as she then was in Vis Trading. You have that in your authorities bundle at 32 pages, at paragraphs 27 to 28. Although it was cited as an example of a judge using it as a sense test, if you look at what the judge actually said in that case, she said she had reached the view independently and then simply noted that she found herself in a similar position to the trial judge, without in any sense suggesting that her conclusion was supported by the conclusion that had been reached by the trial judge.
So which paragraph is that?
I'm so sorry, paragraphs 27 to 28. Which we respectfully suggest is actually a different approach from that articulated by Mrs. Justice Moulder in this case.
Doesn't necessarily make Mrs. Justice Moulder's approach a wrong one.
Of course, all that I was indicating was that the apparent reliance by Deutsche Bank on the approach in this trading doesn't fortify or give any support to the approach that was adopted by Mrs. Justice Moulder in this case. And as regards that, we say it is the wrong approach. It is.
You can't use the judge's previous findings as a reality check. That's basically the point.
You cannot use another judge's findings to say, well, I don't find him credible and I'm somehow fortified in that opinion because 9 years ago, another judge found him not to have been credible when he gave evidence on that occasion. And insofar as Mrs. Justice Moulder did, as she clearly did, fortify her conclusions on general credibility, which, as I've indicated in all the references we gave in opening, carried over to all the subsequent decisions on relation to the particular ones, that is simply not a proper basis, we say, upon which to make a conclusion of credibility. The second point that we addressed is the fairness and abandoned allegations point. The whole procedure was designed and devised to ensure fairness to Mr Vik in circumstances where he faced the huge amount of evidence contained in Part 1, and hence the linkage between the grounds of contempt and the paragraph numbers identified in the application notice of Mr Hart's affidavit on which reliance was placed. And therefore we do say that if and insofar as a ground of contempt was abandoned, that carries with it necessarily paragraphs, and could properly be understood to carry with it the paragraphs of Mr Hart's affidavit that was said to be supportive of that, because in dealing with the other allegations, which remain live, Mr Vik is entitled to, and was entitled to, assume that the paragraphs that were relevant to those allegations were the ones identified in respect of that ground of contempt, and not the ones that had been deleted in relation to another ground of contempt. And the paragraphs of Mr Hart's first affidavit relied upon are indeed from the deleted grounds and the deleted reference to the paragraphs. I mean, that was the whole purpose of having a linkage between the grounds and paragraph numbers in Mr Hart's affidavit, so that Mr Vik knew the evidence he was required to meet in relation to the specific allegations. Therefore, Mr Vik was entitled to assume that he no longer had to address the evidence raised in the paragraphs that were not said to be relied upon in relation to particular allegations of contempt, and therefore in our submission it was not fair and appropriate for reliance to be placed on cross-examination, which by definition would have been on a matter that was not thought to have been live when coming to conclusions in the judgment.
So you're saying effectively that the abandonment of the other contempt applications created a fetter on the general rule that you can cross-examine somebody on credibility on anything that's relevant to credibility?
Well, 2 points. Firstly, it was identifying what was relevant from the evidence that was going to be relied upon. And this is quite important when one looks at it from the credibility point of view. If you're cross-examining to credibility, you have the rule, as has been identified, that you can't then adduce evidence to counteract an answer that you're given. But in essence, you'll get round that. If you put in a load of evidence, you say that it's not in support of my contempt allegation, and I'm not relying upon those paragraphs, but then you do rely upon those paragraphs for some other purpose, which is, in effect, putting in the evidence to contradict an answer that's given in relation to credibility. So it defeats the purpose of the rule of...
Well, no, you're not contradicting the answer. You're putting the evidence in as a foundation for asking the question in the first place, which is a different thing altogether. You're not... the evidence is there, and you say, well, what do you have to say about this evidence, Mr Vik? Then you can make a submission that his answer is or is not credible. But you're not putting it in to contradict his answer.
Well, respectfully suggest that the whole exercise that Deutsche Bank has embarked upon in these proceedings is, and indeed did below, was to demonstrate by reference to the evidence that the answers given were wrong. That is the basis upon which they are asserting that contempts were established. And that's why it links into the second point, which is that it's not entirely clear whether, from sometimes, whether this is evidence and arguments that were being relied upon in support of general credibility or specific aspects, because it is being said in submissions, well, it's all right for us to rely upon it, because actually the allegations in relation to the partnership interests were still there, because they were still there under the documentary part of the grounds of contempt. And the difficulty with that argument is that under the documentary grounds of contempt, the paragraph numbers of Mr Hart's affidavit that are to be relied upon are identified, and they do not include all of these bits that we've been going through, or the basis of the allegation that Mr Vik gave wrong evidence in relation to the abandoned allegations. So we say that doesn't work. The sort of linked point, it has to be put in a context, obviously, and you've got the letter from 17th December 2021 at tab 40 of your bundle, which is the basis upon which the amendment application was going through. And the purpose of it was specifically identified as being to narrow the range of things that had to be considered. Page 995 at paragraph 2 of the letter from Freshfields, it is said in terms that he proposes, the Deutsche Bank proposes to narrow the scope of the matters that Mr Vik and the court will need to consider at the substantive hearing in May 2022. And the purpose of the amendments was in terms to narrow it, which i.e. removes the allegation and the evidence that's been crossed out which is purported to be in support of it. And that is a fair and reasonable interpretation of what is being advanced as the rationale for what is being done. And yet what is now being said is no, that's not true. Actually, anything in any of the material that was previously before, even relating to other allegations which we've now abandoned, is game in the contempt allegations. And that's a complete reversal of the position adopted. And so from that point of view, we say it's not a fair approach, and it wasn't a permissible approach to take into account the material from which the bank had avowedly withdrawn by this amendment application and the covering letter. And the bank is entitled to identify the scope and scale of its case. Having done so, Mr Vik is then entitled to rely upon that as narrowing and identifying the case that he has to meet and what is the foundational material in relation to the partnership, the Carlisle deed document, is not something that had survived that amendment process. If and insofar as it was alive on the documents, it was supported by, or purported to be supported by, the paragraphs in the amended application which did not specifically include these paragraphs. And so we say that is not a proper basis upon which to proceed, to include those allegations having abandoned them. And the position in relation to Carlisle I've gone into in some detail, that the position in relation to Sarek is in some ways even more stark, because the position in relation to Sarek was not addressed at all in oral submissions. There's no suggestion that the allegation was somehow kept alive by, or there's no basis for the suggestion that the allegation was kept alive by the footnote to Mr Hart's first affidavit, paragraph 258D, because that is in context to be read as a reference to Sarek in support of the allegation by the bank that Mr Johansson had access to information. So that's a documents point as to who was the owner of Sarek, and has got nothing to do with the point for which it was in the event actually relied upon. So the So the having abandoned those points, we respectfully say that there was no basis for relying upon them either in submissions to the limited extent that they were, but certainly not in the judgment. And what we had said in our closing, paragraph 130C, was that the bank's approach was unfair and cannot be taken at face value because Deutsche Bank seeks to pray and aid withdrawn allegations as part of a general impression of wrongdoing on the part of Mr Vik. And that's the whole point that was being made there. We've made the point below and we're entitled to sustain it above. I've given you the points at which objection was taken to the lines of questioning. It's not, certainly not my practice to spend my whole time jumping up and down objecting to lines of questioning, and nor, I would suggest, is it the normal approach in proceedings to address that. Ultimately, and by and large, the questions take place, you intervene when you have to, and ultimately you deal with the matter in closing. And we did deal with the matter in closing, as I've indicated, by saying that it wasn't right and proper for those issues to have been addressed and dealt with in the way that they were. And obviously and clearly, the danger that emerges from abandoning that approach is that you get findings in the judgment against Mr Vik on an issue and on a basis which he could not legitimately have expected. And a classic example of that is the two signatures point. That suggestion made very strongly, the decision, the finding made very strongly by Her Ladyship, that Mr Vik must have appreciated that the document that he tendered in 2015 was not the last version of the document, because he signed version 6, and therefore in those circumstances he would have been aware that there was a second, later, different version. Now that is a real problem. In answering the point this afternoon, it's notable that Deutsche Bank took you to Mr Hart's first affidavit, paragraphs 146 and 161. That was precisely part of the evidence to which references had been deleted in the application for contempt at core bundle tab 11, page 312, and therefore not evidence with which Mr Vik should have had to deal with. And it was then suggested this afternoon that it was only going to documents element of the grounds, but as I've indicated, the difficulty with that is that the paragraphs of the evidence that are supposed to be being relied upon in support of the documents part of the grounds of contempt do not include those paragraphs. And so that simply doesn't work. And it wasn't Deutsche Bank's case. It wasn't put to Mr Vik that he had signed twice. So that this conclusion, and that's accepted by Mr Laney, this conclusion of the judge that it was signed twice, and therefore on the second occasion he would have been cognizant of the fact that there was a later version, and therefore in tendering the earlier version he must have been aware that the earlier version was not the later version, which he'd also signed. By definition, that can't be right. And it's not the case that was put. And of course, it wasn't put because it would have been clearly factually wrong. And yet, as the judge has said in her judgment, and in particular, I gave you all the paragraph numbers before, but references made to by Deutsche Bank to paragraph 95, but they overlook paragraph 92, which is absolutely crucial to a lot of the later findings. Mr Vik's evidence was that he signs documents without reading them. However, this evidence fails to provide a satisfactory explanation as to why, even if he doesn't read them, these 5 deeds were signed twice, i.e. both versions 5 and 6, and that finding simply can't stand. And the explanation that the documents were given to him by Mr Johansson to disclose does not explain how Mr Vik came to sign 5 deeds twice. And as I say, that can't stand. And at paragraph 93, Mr Vik disclosed the earlier versions of the deeds. Court would have to infer that it was mere chance that he had retained and then disclosed only the earlier versions, rather than the later version, which is adverse to his case. It being suggested, of course, that the later version was one that he had also signed. And of course, that's clearly not factually the case. And as I've indicated in the cross-references that I gave to the court in dealing with this matter in opening, that basis of criticism of the evidence of Mr Vik is fundamental to her decision that his general credibility is not to be relied upon. That decision in the earlier part of this earlier sections of the judgment, that his general credibility was not to be relied upon, carries over to each of the individual particular items. And a core element of the basis upon which, of course, we'd be entitled to run this point insofar as it is not a manifestation of the other point that we did clearly run, namely the fact that you are not supposed to make a decision, we say, on the basis of evidence and findings that have been withdrawn, as it were, is that it is difficult to see how we could or should have brought evidence or argument in relation to this before, because until the judgment saying that there were two signatures and Mr Vik's knowledge of the second of his signatures to the version 6 document demonstrates that he's deliberately putting forward false documents, until that, the case hadn't been put that he had signed version 6, and therefore we couldn't have known that we should have addressed the issue of whether he had signed version 6. There is some, I'm not quite clear in my mind whether there is criticism or not of the fact that the version that ended up in document 6 was witnessed, but appears to have been witnessed without Mr Vik's signature being reattached or reappended, as it were. Just briefly in relation to that, the first point is that is what Debevoise suggested should happen. And I appreciate the points that are being taken about the legitimacy or otherwise of a witness being asked to add their signature to an existing signature. But in the, if we take the supplementary bundle 3 at tab 24, at page 717, in the 26th of August email from Debevoise to Mr Johansson at item 3, Debevoise said, "We noticed the signature pages did not include the requisite witness signatures. Can you please coordinate to have these pages properly executed? We are happy to send back the original signature pages to facilitate the process. Apologies in advance for any inconvenience this may cause." And it's difficult to see how, or at least it's a perfectly legitimate understanding of what that sentence meant, to be told, here we're sending back the original ones, please get them witnessed, rather than...
Not the original signed ones, Mr Matthews, because they're asking for it to be properly executed. And if they're asking for them to be properly executed, what they're doing is sending you a blank one back, which has not been signed by anybody, so that it's in the original form of the original document, and you get it properly witnessed. I mean, I don't think you would read that necessarily as, can we sort of pretend that it's witnessed, please?
Well, I'm not suggesting it's pretend that it's witnessed, but what it... I mean, the only reason to send back the original... I mean, the word original doesn't mean draft. The original signature page is a page that has originally been signed. And that is what original signature page must be taken to mean. Anyway, it's a reasonable understanding of what that means. There's obviously all of this turns on questions of the circumstances in which it's now being suggested that Mr Vik signed version 6, or has been found by the judge that he signed version 6, when all the evidence is that he didn't sign version 6 or a later version. And we don't know in what circumstances Mrs Vik was called then to sign whatever Debevoise sent back, because that point wasn't being taken that he had in fact signed again version 6. Ultimately it has no, the witness bit of it has no impact on the error in the judgment, because there is no suggestion that Mr Vik did indeed sign version 6, rather than that the version that was incorporated into version 6 was the signed version from version 5. Deutsche Bank then tried to rescue the situation by saying, well, the judge relied on matters other than credibility to reach her conclusions on the specific grounds of contempt, but I've already dealt with that it is a fundamental point. Those other matters were, in many cases, a question of drawing inferences from the findings which the judge made on other points. And then inevitably the question arises, well, how did she come to the decision that she did come to on the other points? And the answer in relation to that, we respectfully suggest, is that part of the process that she went through was that, having formed a thoroughly negative view of the credibility of Mr Vik, all of the points that, or many of the points that she had to address in relation to the specifics of the other items, for example, the 2012 sale agreement, and I'll come back to that in a moment, are inevitably infected by the fact that she doesn't accept, significant part because of her decision on general credibility, the explanation given by Mr Vik in relation to things, but she takes the opposite position in relation to it. So there's one particular regular theme in Deutsche Bank submissions, which is, oh, well, Mr Matthews conceded that there was a deliberate attempt, it's almost suggested, deliberate attempt to mislead the tax authorities, and so that is conceded by Mr Matthews. No, it isn't. What I said was, given Mr Vik's practice of signing documents presented to him without checking them, and in reliance on those who presented them to him for signing and whose job it was to do so, it is more likely that in doing so he had inadvertently, rather than deliberately, misled the tax authorities. It is more likely that he had inadvertently misled the authorities than that it was accurate that at a later date Mr Vik was lying to the court. Now, obviously, and it's the Deutsche Bank skeleton argument at 51 subparagraph D and footnote 18, it is, we respectfully submit, not remotely comparable to say that because Mr Vik had a practice of signing documents without checking that everything that in it was accurate, because he relied upon others to present the documents to him, that therefore he's the sort of person who would deliberately lie to the court. And we say they're not
rather than anything else.
I'm so sorry, my lady.
Recklessness rather than anything else.
Well, everybody who is operating at the sort of level of a billionaire businessman has an enormous number of affairs to deal with, and they have people whose responsibility it is to try to ensure that they do what they're supposed to do and what they need to do. And in all one's daily activities, there are some things that one takes and has time to take more care over, and other things that one has less. And obviously, the greater the burden of the affairs that one is trying to deal with, and the greater the number of people that one has employed to try to do things for you and upon whom you rely, the greater the risk that you sign something which is not entirely true. Ultimately, many people may get their tax returns sent back to them from their accountants and are told to look very carefully at that every entry is accurate. And if one works on the presumption that everybody who fills in that form reads through the hundreds of pages that have been returned by the accountant and make sure that every single entry, not only they understand what is supposed to go in each entry, but also that the correct figure is in there. Is it reckless if somebody says, well, that's what I have my accountants for, and I expect them to get it right? And so it's even that's putting it a bit high, but it certainly, I suggest, doesn't equate with the suggestion that a person is deliberately trying to mislead the court when being asked to focus on particular issues and aspects in relation to that. In relation to turning to Beatrice and the trust, in their oral submissions, Deutsche Bank appeared to be suggesting that the Connecticut judgment demonstrated how Mr Vik kept a close eye on the activities of Beatrice, and somehow carrying over from that to, well, that shows that he kept a close eye on the activities of Beatrice. I would flag up, and it's important that one does understand in the context of these various judgments, because it comes back again in the context of the sale agreement and Mr Justice Cook's judgments. One has to look at what the court is looking at any given time. What the court was looking at in Connecticut was the position in 2008, prior to the transfer and leading up to the transfer of the assets to Beatrice and of the Beatrice shares to the trust. And therefore it tells you absolutely nothing whatsoever about what Mr Vik did and how he conducted himself in relation to Beatrice's assets after the transfer of those assets in late 2008. In relation to the trustees' powers and the grantor's powers under the trust, the starting point, we say, is the intention in relation to the assets of Beatrice, once taken over by the trust, was that it would continue as the saving company, which it had been before, and would continue with the maintenance of the status quo. And I'll come back in a moment to the evidence in relation to that. The setup, therefore, of the trustees did not require the trustees to have great business and financial skills and acumen, because that was not how the trust, let alone that's not how Beatrice, let alone the trust, was supposed to operate. So obviously, if the intention had been for Beatrice and the trust to operate some aggressive investment management profile, such as the sort of things, the straddles and strides, or whatever, or stripes, which was being referred to, no doubt the trustees appointed in relation to this would have been, who would have been charged with looking after those assets, would have been changed to reflect that. But that is not what the intention was in relation to the setting up of the trust and the transfer into it of Beatrice and the continuation of the performance of the role of Beatrice as, in effect, a savings company with cash and cash equivalent assets. And there was no hint of any evidence and nothing to support any suggestion that the Beatrice and through Beatrice the trust was going to be managed with some sort of different risk profile after 2008 compared with the situation before. And there was clear evidence in relation to the status of... Sorry, would you look... Court, just give me one moment. I have lost one particular piece of paper which I need at this point. I don't know how I've managed to achieve that. But it's found itself interleaved into my other papers. But apologies. And one of those magical disappearing tricks by becoming attached to the back of the judgment.
Right, well, if you found it again, that's good news. At least I assume it is.
I'm grateful, my lord. Yes, it is indeed, because what I wanted to do was just to remind the court in the context of looking at the answers that were given by Mr Vik in relation to the Part 71 questioning. As Deutsche Bank have stressed, there was a context to it. We accept there's a context to it. The context was the background knowledge as to what the state of affairs was with Beatrice and what was happening to Beatrice prior to the transfer into the trust, and then what at the time of transfer was intended to be done, i.e. to maintain the status quo. And therefore, when you come on to the later question of, well, do you know what the assets are in 2015, August, December 2015, the answer, legitimately, we say, is, well, I don't, because I'm obviously not being asked the questions I've been asked before, namely, what was the purpose of transferring them into, we were going to maintain the status quo and so on. So the asset class and so on was something that had already been investigated. This was a further question, and obviously intended to be a more explicit and express question. And equally, and I'll come on to look at this in a moment, when Mr Vik says, well, I don't know anything, he's obviously not saying he's not literally saying I know nothing, because he's already given answers showing that he clearly did know something. He knew that the intention was to maintain the status quo as the investment strategy. So if we just have a look at that, if one takes Supplementary Bundle 1, tab 9, and if I may, I'm going to, because of the pressures of time, I'm going to give you the court some cross-references and then particularly go to the heart of it.
It's a supplementary bundle or core supplementary bundle?
It's a supplementary bundle because it's the run of it's the run of the transcript rather than just some very limited extracts from it.
Yep.
And so, and it may be that the particular bit that I want to refer you to, you've already marked up in the core supplementary, but the background to it is that by the time we got to page 19 of the transcript, 19 of the bundle, which is into the 60s in the transcript in relation to the cross-examination about Beatrice and the trust, Mr. Vik had already been cross-examined over and given proper answers to which no objection is taken by Deutsche Bank, that he had transferred his shares into the trust, that he had transferred the cash into Beatrice in October 2008, and that Beatrice had held those funds when Beatrice was transferred into the trust, that he had not transferred anything else into the trust since October 2008, that none of the trust assets had been revested in Mr Vik. I'm conscious of the fact that I'm not giving you any of these cross-references as I go along, and I apologise for that. But the relevant cross-examination, if you pick it up, first of all, at page 8, 9 and 10, you see of the bundle, you see the points that I've just been referring to. So there's a history, there's a background to this, before we come on to the questions of which objection is made. And then at page 14 of the bundle, at pages 42, line 16 to 44, line 11, there is discussion of the continued operation of the credit facility subsequent to the transfer in and of the transfer of cash backwards and forwards between SHI and Beatrice. And then at page 15, again, that there had been various payments to between the companies pursuant to a credit line, resulting in a net transfer of $25 million to SHI, that Mr Vik had not transferred further monies and assets into Beatrice, that's at page 18 of the bundle, in the internal page 59, that he'd not transferred further monies or assets into Beatrice or the trust since 30th of October, and could not recollect any company associated with him doing so either. And then at page 19 of the bundle, at page internal page 61, line 2, your wife also said in her deposition that the investment strategy of the trust was to maintain the status quo. Do you agree with that? The straight answer, yes. There's no obfuscation. There's no hesitation. It's a straight answer to a straight question. That's how he viewed the position. Yes, it was to maintain the status quo. And then as it goes on thereafter, he's asked whether his understanding was that Beatrice's assets were still in the trust in 2013. And he says, yes, that's his understanding.
No, he doesn't. He says,
It's what she said.
says that's what she said. Is it right that they were? I don't know.
I don't know.
That's
no, that's fair
completely
enough.
the opposite.
My lord, yes, I'm sorry. That's quite right. But he's given, I mean, in a way that illustrates the point. Where he knows, he gives the answer. The previous line, line 5, answer yes. But in relation to the point which he doesn't know the answer to, he says, I don't know. And that's perfectly reasonable in our submission, and not. But it does demonstrate from the fact that he has given positive and clear evidence that the intention in the setting up of the trust and through Beatrice was to maintain the status quo in relation to the investment strategy of the trust, well, of Beatrice, and thereby, Beatrice. Demonstrates in our submission a straight answer to a straight question as to what he thought was going to happen. And that
Well, doesn't it rather suggest the opposite? That he's saying, I simply cannot tell you anything about the position from 2013. Anything at all.
From 2030.
Yes.
Yes, what he's saying is that by the time he gets to 2013, he doesn't know the position. But at the time when the trust was created and set up, the intention was to maintain the status quo. And therefore, this is in the context of the nature of the trustees that are established and the use of HSBC to manage the fund. Is it so odd? They're not talking, they're not contemplating. They didn't intend, when the trust was set up, that it was going to actually be investing in straddles and stripes and things. And therefore, it's not surprising in our submission that in those circumstances, when he comes on to the question of the position in 2015 as to his knowledge, his background, the background is what he said, it was to maintain the status quo, and so therefore the his expectation, of course, would be that it would be cash and cash equivalents, because he said that the intention with which it was set up was that it would maintain the status quo. And so therefore, when one comes on to the questions of which complaint is made, namely the later questions as to, well, do you know what the assets were? He'd already answered pages and questions about Beatrice and the trust. No objection taken to any of that. And so if one then goes on to, and I'm in the court's hands as to, we have to go for this to the core supplemental bundle. Tab 6, page 57. This is the cross-examination of the committal proceedings, and the criticism is made, oh, well, he's not answering the questions, and he's giving different answers, and he's not giving an answer when pressed. If one looks at the answer that he gives at page 57 of the bundle, internal page 79, Mr. Laney says at line 4, I'm just going to be very clear, reread the exact question. Your case is that you didn't know what the position was in August or in December 2015, and therefore you do not need to advance a case that you don't understand the questions. Your case is simply you knew nothing. Answer, I didn't know the answers to those questions at that time. I did not know them. As far as not understanding the question properly, that's a matter for counsel. But I didn't have the information to say there was 100 or 200 or 500 of this or that. I did not know that information. No, I did not. So what he's saying is he didn't know exactly whether it was 100 Norwegian bonds or 500 gilts or 400 or 200 Mexican Railways bonds. That's the whole point.
He doesn't need to say that. All he needs to say is, I know nothing at all
Well,
about what's there.
well,
That's the point that's being put to him, and that is the point that time and time and time again he obfuscates. And he doesn't get out of that particular conundrum. However nice a gloss one wants to put on it, Mr. Matthews, he's avoiding answering the question in the way that an honest witness would answer if he really knew nothing. He'd simply say, I'm terribly sorry, I know nothing, I told you all along I knew nothing. But to say, I don't understand your question, is not an answer to the question.
well,
It really isn't.
your ladyship is obviously going to read it as much as any of us can. But all I'm saying in relation to that is that it is entirely consistent with his position that he had not understood the question as being, in a sense, a repeat of what he'd answered before, namely the asset class, the asset type, the fact that it was intended to be the same type of assets as it was before. But now he'd understood being asked, did it have X? What quantity of this did he have, or what quantity of that? And he's saying, I can't tell you whether it had 100 of this or 200 of that or 400 of that. That's how he understood the question, and that's the answer he's explaining again in that passage. Yes, I should, in this context, my Lord Justice Mail did ask me for cross-references to Mr. Vik's evidence from the committal hearing as to his understanding of the questions. And if your Lordship hasn't already had it, there's two references. First of all, to his affidavit, which is Vik 1, paragraphs 18 to 26, at Supplementary Bundle, tab 13, pages 444 to 446, and transcript, day 8, pages 67, line 12 to page 80, line 20, which we have in the core supplementary bundle, tab 6, at pages 54 to 57, especially at 56.
Yes, thank you.
In relation to the role of HSBC, the point up we have on this is simple, that the judgment at paragraph 156 says there is no evidence. To about 5 lines from the bottom of paragraph 156, her ladyship says, however, there is no evidence to suggest there were fund managers appointed to manage the assets of Beatrice, and I've shown you already the deposition of Mrs. Vik in core supplemental bundle, tab 36, pages 276 to 277, which with respect is evidence to that effect. And therefore, if insofar as the judge is, it's not a question of weight to be attached to it. With respect, it's simply overlooking that significant piece of evidence. The line of credit point, we simply reiterate, and there's no answer to this, the sums involved in the credit line represented only at most 10 to 12% of the sums in gross terms transferred into Beatrice in cash or cash equivalents, and culminated in a net flow of only about 3% of the assets from Beatrice to SHI. And in our respectful submission, there can be no sensible basis upon which reliance can be placed upon the existence of the credit line and the operation of the credit line, therefore, as demonstrating that Mr. Vik, who, as has been explained, expected the status quo from the investment management basis to continue, namely cash and cash equivalents, that somehow draws on Beatrice of this sort of level would be in any way compromised or would require that degree of proximity or of analysis. It was suggested that I had conceded that the role of protector required him or her to know something about the performance of the trust and underlying assets. In fact, that is something that I resisted in questioning from my Lord Justice Mails, and it's a transcript of this hearing, day 2, page 169, lines 13 to 18, and I did so on the basis that in the particular context of this case, where somebody has been advised to distance themselves from it, there is a perfectly good basis and inference as to why that should not be the case. The assets of SHI held by Beatrice, as my Lord Lord Justice Nugee said in argument this morning, and with respect, that was the point that we were trying previously to articulate, that the concept of SHI assets has a legal meaning, and a witness is properly not entitled or expected to give the benefit of his legal advice in relation to that unless he's giving expert opinion on the relevant area of law, which obviously Mr Vik was not. And the ownership, obviously, of the assets is a controversial issue. The approach of the Connecticut court, of course, was that Mr Vik was entitled to put the funds from SHI into Beatrice, and the approach of the courts here has been that Mr Vik could have put SHI in funds, not that they were necessarily SHI's funds, in order to make a payment to Deutsche Bank. So in our submission, it's a legitimate answer to say that you do not know what you are actually being asked in relation to that. So if you say, do you know what assets of SHI Beatrice had, it's a legitimate answer to say no. Mr Vik dealt with that in his first affidavit at page 22 in the supplementary bundle, tab 13, the supplementary bundle 2, tab 13, page 445. Turning to Devon Park and the sale agreement, this is the 2012 agreement under which obviously we say that SHI received consideration for the assets. Much is made of the fact that later SHI didn't receive any consideration when the assets are transferred to Universal and so on. You wouldn't expect them to receive any consideration. SHI has already received its consideration in 2012. And that's the point linked into the payments which were made in 2012, which we say represented the purchase price under the sale agreement in 2012, and which the learned judge suggested could have been, as equally, could have been loans. And one of the difficulties with that is, if it could equally have been loans, then there's no basis for concluding that Mr Vik is wrong, or that he's telling an untruth, when he says there weren't loans, there were the payments in relation to it. So that's the difficulty for the Deutsche Bank's case on it. It's not enough for them to establish that this could have been a loan. If the position is that they were, and they were said to be, payments, and also obviously in relation to the additional evidence point, the document produced in 2014 as to the level of loans outstanding in 2013, that is something where it remains the fact that loans were listed. It's being said, oh, well, this was a deliberate attempt to load SHI with debt. One might have thought in those circumstances that if there had been those payments made as loans, they would have been on the list to demonstrate that there was debt there. And they're not on the list, and that's what we rely upon it for, to demonstrate that, in fact, there is no proper basis for discounting the argument, and that's enough for my purposes, that they were actually payments pursuant to the 2012 sale agreement. The position in relation to the contemporary documents evidencing the sale of Devon Park, it's very important that you look carefully at the way in which this was addressed. It is not right that we resisted the inclusion of the agreement that had been made in July 2014 between VBI and Universal, which Mr. Robinson referred to in his witness statement. And our closing is in the supplementary bundle 2, tab 18, at pages 131 to 133. That can't be a good reference. Sorry, the supplementary. and it's dealt with in our closing at paragraph 75. First of all, at the bottom of 131.
631.
I'm sorry, my lord, that's my confusion. I meant to say core supplementary bundle. Because what happened was that, faced with a very large number of documents, we were invited to reduce the number to a core, which we did, but I'm not sure ultimately that's proved a total solution. At bottom of core supplementary bundle, tab 18, page 131. The point is made, it is now clear that there are relevant documents which undermine Deutsche Bank's position obtained by way of disclosure from parties to the substantive US proceedings who are not parties to this application, which have not been put before the court by Deutsche Bank or even mentioned. And then at the bottom of 132, in Roman 5, the court cannot have any confidence that there is not other relevant documentation or evidence going to the issue and potentially undermining Deutsche Bank's case that has not been produced. As Mr. Hart acknowledged, there have been disclosure orders, including in respect of VBI and Universal and US proceedings. Mr. Hart did not deny that, this is in the cross-examination of Mr. Hart, did not deny that Deutsche Bank had not produced all of the disclosure from those proceedings, was unable to tell the court what documents might be available, and was certainly not able to reassure the court that all relevant documents have been put before it. For the avoidance of doubt, Mr. Vik says it's wholly improper for Deutsche Bank to seek to deploy Mr. Robinson's fourth statement, not simply to concede that the VBI Universal Agreement exists and to apologise to the court, which could and should have been done in correspondence, but to go further and pray in aid the undisclosed document. So it's not a document that we're stopping coming in. It's an undisclosed document in support of its case for contempt. It's far too late for Deutsche Bank to run a new case on a new document at the last minute. Deutsche Bank does not have and has not sought permission to rely on Mr. Robinson's statement. It's not an affidavit. It contains hearsay from unidentified sources, and it would be entirely unfair to allow Deutsche Bank to make a case for his committal based on a document that he's not even seen and which is not in evidence. And the point is this, that Mr. Robinson's, the skeleton argument that was put before the court contained an assertion that there are no contemporary documents which in any way support the existence of the 2012 sale agreement. That bit of Deutsche Bank's skeleton had to be removed because the bank, aware of this other document, realised that it couldn't be sustained. And what we were saying is that in those circumstances, you should remove it and explain that the reason you're removing it is because there is another document. What you cannot do is to put in a witness statement in the correspondence bundle and then rely on the contents of the witness statement as to your reasons for why you say that that document, although in existence, doesn't actually support, but actually supports the Deutsche Bank case. And so...
I mean, the bottom line, indeed, the bottom line of your paragraph is that both sides had access to the agreement and neither put it in evidence.
No, my client didn't have access to the agreement. My client did not have access to the agreement. It was subject to a closure order in the Delaware court. SHI had access to the document, but my client did not. And so the impact of it is this, that we know that in relation to Devon Park, we say 2012 sale agreement gives rise to the transfer of the interests, but of course just between SHI and VBI, because Devon Park, as the general partner, was not a party to any agreement to transfer, and their consent to an assignment was required. April 2014, you had the disclosure of the sale agreement, the 2012 sale agreement. July 2014, you have the VBI Universal Agreement, which is referred to and discussed in Mr. Robinson's witness statement, which he sought to put before the court, and which we say quite properly, as a fact, it should be before the court that there is a contemporary document, which appears to bear out or justify, as it were, the 2012 sale agreement. But what you're not entitled to do, as it were, is to, they rightly withdrew the suggestion that there were no contemporary documents because there was a contemporary document. And the existence of that contemporary document could and should be taken into account. And then in August 2014, you have the SHI Universal Agreement. And it is being said, well, but Devon Park didn't know anything about all of this. Well, there are all sorts of reasons why it might have been thought desirable or appropriate on the part of SHI and VBI not to inform Devon Park of the fact that they'd entered into an agreement between themselves to transfer the interest in Devon Park. But of course, when it was being transferred to Universal, it then did become necessary to notify Devon Park in order to get their consent to the assignment, and that's what gave rise to the communications in 2014.
Now, how much longer are you going to be, Mr. Matthews? We are close to running out of time.
We are indeed, my lord. I thought I had 45 minutes left, which I'm not sure that I've fully used yet, but I may be wrong about
From
that.
now?
No, not now. No, not from now, well, in total, my lord. Well, I'm told I started now. Well, in that case, I'd better sit down quite shortly.
Well,
May I have 5 minutes?
If you can, yes.
Yes, I'm grateful.
And I don't want to cut you off if there's anything important that you need to say. Obviously, we have been over quite a lot of this ground twice now, but if you can do it in 5 minutes or so, then that's fine.
I shall try to achieve that, my lord. Yes, I appreciate we've been over it, but some of the points haven't quite been through in the way that the true position has emerged. So that's why I'm trying to
No, I understand.
Some of these points are quite difficult. The documents 2012-2014 showing SHI owning Devon Park interests, it is obvious that they would continue to appear to own Devon Park interests because, as at that time, Devon Park was unaware of the fact of the transfer taking place under the 2012 sale agreement. That's common ground, there's no doubt about that. So it is not surprising that communications continued in that period, and from a legal point of view, transfer of the interest had not taken place. And then post-2014, the point is made by Mr Vik that the correspondent may have been addressed, as it were, Dear Alexander and so on, but it's actually sent to Universal. The address which they used is address, bizarrely, we point out, that the communication is sent to the address of Mr Vik, but in Monaco, but is finished with the word Panama. So that, we say, just demonstrates the carelessness with which their accuracy of these matters were being dealt with. A point is made that that Mr Justice Cook had said that the 2012 sale agreement would have been in some way relevant to the trial and therefore would have been expected to have been disclosed, and therefore there was somehow a late disclosure issue. Well, the bits that your lordship were taken to, paragraphs 82 and 87 of that judgment, they're actually dealing with loans said to have been entered into in 2004 and 2006. The hypothetical portfolio runs on the basis of the assets available in 2008 and what would have happened on the basis of the investment of those assets. Obviously, had the hypothetical portfolio run from 2008, in 2012, there would have been no sort of forced sale of the illiquid assets under the 2012 sale agreement, which in fact occurred because SHI would not have been raising funds for this litigation. And so it's difficult with respect to see that those paragraphs of Mr Justice Cook's judgment don't appear actually to suggest that the 2012 sale agreement would have been relevant to the trial, and therefore the suggestion that it's a late disclosure is questionable, to say the least. The terms of the 2012 sale agreement, if again you start with the assumption that you don't believe everything that Mr Vik says, and you assume everything against him, and you assume that it is a contract between commercially separate parties rather than between father and son, well, you can look at a lot of the clauses and say, well, that's a slightly odd clause to have, and that's a strange clause to have, and that's a slightly odd clause to have. That's not the factual scenario. First of all, we say you shouldn't be starting from that premise in relation to credibility for the reasons we've already indicated. Secondly, there's no question. It was a relationship, a contract between father and son, by which the son was provided with 300 million Norwegian kroner to fund the litigation, and his father was willing to do so. They were on good terms, and there is no reason to suggest, first of all, that every single I would be dotted and T would be crossed in an agreement which would be entirely compliant, as it were, and also that, for example, the due diligence that would need to be carried out, sort of points that were raised by my Lord Justice Nugee in relation to that. If you start instead from an assumption that this was an agreement entered into between father and son to fund against the fact that 2008 SHI had effectively stopped its pre-existing activity, was left with illiquid assets, and the litigation. 2012, the decision is taken to dispose of the illiquid assets, transfer them over to the father, and take instead a significant injection of cash to fund the litigation, which, of course, as is pointed out, if the litigation had been successful, then SHI would have done extremely well. But that is not, in those circumstances, a surprising context. If one then looks at the terms of the 2012 sale agreement, they make, not in the perfect legal sense, but they make perfect sense for an arrangement between a father and son to achieve that sort of deal. In relation to Norwegian law, may I just make the point that what we had said below was there is no evidence in relation to Norwegian law. And you asked me for the cross references. I can give them if that assists. But in our closing, at paragraph 121 FI, supplementary bundle 17, page 562, and the oral closing transcript day 8, page 74, line 13, at supplementary bundle tab 7, 279. And IFA I've already dealt with in this sense that there is nothing further relied upon in relation to the first limb of IFA than the sale agreement of 2012. That's effectively the same point. The other points, again, are nice points in inverted commas, but they're no more than that. So the Johansson schedule, which said that SHI had IFA shares in 2012, well, strictly speaking, as a matter of law, it may well be right to say they didn't actually have the shares. They had a right to have transferred to them as shares of equivalent value. But it's only going to be if you start from the presumption of general attack on credibility against Mr Vik, if you imply that or infer that all of these points must be assumed that somehow this demonstrates crookery on the part of the participants involved. If you start from the other perspective that these are not English law experts, they're producing a list, it is broadly accurate to say that as at 2012, amongst the assets that VBI acquired was the IFA shares, in the sense that the SHI had a right to compel production to them of those under the securities agreement, and that right was being transferred to VBI. And the fact that in the aftermath of the liquidation of Vik Beteiligung, that those shares were passed to, as fully explained, were passed to Mr Vik in order for him to sit on the board of IFA pursuant to the settlement agreement reached with the IFA, and to have and exercise the voting rights in relation to those. That all makes total sense. Who ultimately had the shares been transferred to? Answer, under the 2012 sale agreement, clearly to VBI. In the context, if one's looking at it without prejudging the whole thing of saying, well, everything Mr Vik says can't be true, does it make sense? Yes, Mr Vik's company was in no hurry to father's company was in no hurry to receive the shares. He got the shares into Mr Vik's hands, and then as and when in 2014 they were no longer required for Mr Vik, pursuant to the 2012 sale agreement and request from VBI, they were transferred to Universal. And none of that is, in our respectful submission, surprising. And finally, in relation to the documents, just very shortly, bearing in mind that in 2008 the economic activities of SHI had essentially stopped because of the collapse under the litigation, or the matters that gave rise to the litigation with Deutsche Bank, and then the sale agreement that was entered into in 2012, pursuant to which the illiquid assets of SHI were disposed of, combined with the deletion policy which had been going on before and is fully explained by Mr Vik, it is not in our submission surprising that you do not find significant volumes of documents. Some of them, as I say, had already been disclosed pursuant to the disclosure obligations in relation to the trial, and the position in relation to, for example, drafts of the Carlisle deeds, had they been in the possession of SHI. That is precisely under the terms of what Mr Vik identified as his deletion policy, is precisely the sort of document that would have been deleted. So that is not at all surprising that you don't have them available from SHI. So, my lord, I'm conscious of having trespassed on your good nature.
No? Well, thank you very much.
Well, can I just make one point? It was said that the paragraphs of Mr Hart had been withdrawn that I took you to. In fact, in the schedule on the documents at page 313 of Core Bundle tab 11, you'll see the reference in the document section of Mr Hart to paragraphs 211 to 262 as one of the references. Those paragraphs, paragraph 237, cross-refers back to 162. So
That was a point you made yesterday.
I did. I just wanted to give you the specifics.
All right, well, we're going to reserve our judgments in this case. I don't suppose that will come as any surprise to anybody. We're very grateful for the assistance that we have received, both from those with speaking parts and those without speaking parts. We will in due course circulate a draft judgment to those whose identities have been put forward. We invite you to agree an order in the light of whatever we decide. If you're unable to do so, then we will have short, and I emphasise short, written submissions on paper, and we'll resolve it without a hearing. The judgment will then be handed down remotely without the need for any attendance. I'm sure that everybody who will be receiving the judgment is already aware of the strict embargo which applies to a draft judgment, but for the avoidance of any possible future doubt, I emphasise that again now. I think that concludes the hearing, so thank you all very much.